against you. You also have the right to an attorney. This particular proceeding is being broadcast over the internet as a live stream. It's also being recorded. That means any member of the public can log on and watch. When I ask if you understand your rights, that's what I am referring to today. Who do we have first at the jail? And are there any other announcements from the public defender's office before we begin? Okay, hearing none. Who's first?
We have position number 16, Mr. Kemp.
Okay.
Number 19 announcement.
Okay, hold on one second. What is the announcement for 19?
19 is a negotiated plea.
Okay. Okay, and this is Mr. Kemp. Mr. Kemp, your case is 20 CR 003123C. In that case, you're charged with simple assault, family violence, and simple battery, family violence. Do you understand your rights today?
Yes, ma'am.
All right. The announcement I have is, oh, it says hold for announcement. What's the announcement?
We're going to interview him this morning, Your Honor.
Oh, he's not been interviewed, so we can't do this case.
That's
okay.
correct.
All right. How are you going to interview him, Mr. McClain?
Right now in the corner.
Oh, you're gonna, he's, okay. Well, we'll come back to this position. Then can we do an ACDC position then that doesn't belong to Mr. McClain?
Is he on Zoom? Is Kemp on Zoom or?
Yeah, he's on Zoom. That's the issue. So
Okay.
that's why I was asking how you're going to interview him.
I understand. I'll figure it out and get back with the court in just a minute.
Okay.
We'll probably do a breakout.
All right.
Have a seat right here, Mr. Beck.
Okay, so we're not doing ACD. Okay, we're going to do this position in medical.
Position number 11, Mr. Hendricks.
Mr. Hambrick is Will Kelbaugh's case. I'm not sure. He did email me this morning and let me know that he has another court appearance and he would be headed to court after that court appearance. So I'm not sure he's here to handle that case.
Okay, I don't see Mr. Kelbaugh, so we can't do position 11 yet. Is it possible for us to come back to that one?
Yes, ma'am.
Thank you. Can we try and
Mr. Beck?
who represents Mr. Beck? Is it Mr. McClain?
Samantha Adams, Your Honor.
Okay. All right, Mr. Beck, your case is 23 CR 006789A. You're charged with theft by receiving and theft by shoplifting with the offense date of October the 28th. Do you understand your rights?
Yes, Your Honor.
All right. The announcement that I have is a negotiated plea. Is that correct?
Yes, Your Honor.
All right. Ms. Falk, if you would give me the state's offer.
Yes, Your Honor. The state's offer on count 1 is 12 months served, 36 days, credit for time served, 18 days. That is from October 25th of 2023. Balance probated, no contact with Brenna Tamar Mishkovsky. That is Mishkovsky. On count 2, the theft by shoplifting, 12 months concurrent with count 1, served 36 days, credit for time served the 18 days, balance probated, a $500 fine, 40 hours of community service, anti-theft course, and stay away from 3506 Martin Luther King Jr. Drive. That's going to run concurrent with count 1. We would like the defense to stipulate to venue, factual basis, and identification, and we would like to sound from Mr. Mishkovsky if he is here.
All right.
Defensive stipulation.
All right. Thank you for stipulate to those 3 elements. I don't see anyone with that name, but I'm sounding for Brenna Tamar Mishkovsky, and I apologize if I'm saying it incorrectly. If you are here and would like to address the court, this is your opportunity to do so. Okay, hearing and seeing none. Thank you for the stipulation, Ms. Adams. Was that also your understanding of the offer?
Yes, Your Honor.
All right. Mr. Beck, please raise your hand so I can ask you some questions. Do you solemnly swear and affirm the testimony you give today for the limited purposes of taking a plea will be the truth to the best of your knowledge and under the penalty of perjury?
Yes, Your Honor.
All right, you can put your hand down. Thank you. Are you under the influence of any drugs or alcohol at this time?
No, Your Honor.
Did anyone force you to take a plea?
No, Your Honor.
Did anyone promise you anything in exchange for taking a plea?
No, Your Honor.
And you understand you're giving up your right to a trial by judge or jury?
Yes, Your Honor.
And you understand that taking a guilty plea may affect other aspects of your life that I might not be able to anticipate, such as probation, employment, or things of that nature?
Yes, Your Honor.
And you understand the requirements that you have some courses to take, some fines to pay, but you should not have additional time to serve at the Fulton County Jail?
Yes.
All right, and you cannot have any contact with the alleged victim in this case, and you have to stay away from that location on Martin Luther King. Ms. Falk, what is that location? What was it? Do we know?
Let me take a moment. I believe it was Walmart, but let me just double check really quickly.
Okay, that would make sense.
Your Honor, it was a Dollar Tree. The address that was provided on the, that was provided
Okay,
3506 Martin Luther King Junior Drive.
okay, as long as it's nothing like a medical place. And you
No,
understand
yeah.
you can't go back there, sir, correct?
Yes.
All right, as to the charges previously listed, Mr. Beck, how do you plead?
Guilty.
I accept your guilty plea at this time. Is there anything further, Ms. Falk or Ms. Adams?
No, Your Honor, nothing from the state.
Nothing from defense, Your Honor.
All right, best of luck to you, Mr. Beck. That concludes your case.
Oh, it is just a brief correction. It is Dollar General. So-
Okay,
So if we need to write that on the,
we'll put Dollar General.
thank you.
Your Honor,
Yes.
Mr. Pierce announces that he would like to do the negotiated plea.
Okay. That was position 16.
It's PIE, Pierce.
I'm sorry, what number was he? Did we already?
20, it's 20.
Oh, that wasn't a position we had announced yet, though. Okay, thank you.
Right.
All right, and do we know how we're gonna interview the other gentleman yet?
Breakout room, Your Honor.
Okay, so do you need to do that breakout now?
That would be good.
You can connect them to my-
Okay, so can Mr. McLean go into a breakout? I mean, I'm sorry, can jail court iPhone go into a break with courtroom 2 and I take a position at ACDC?
Your
Or does
Honor,
that eliminate all public defenders?
it eliminates it all, Your Honor, but I do have my laptop. It's PD Samantha Adams, and Mr. McLean can use my laptop.
All right.
Okay,
Yeah,
that's
all right.
better.
Thank you.
Mhm.
So that's jail iPhone and Miss Adams' laptop, correct?
Correct, Miss Grace.
So that's going to be for Kemp and for Khan. Who's first?
All right, who do we have next?
Position 9, Mr. Eldridge.
Okay. All right, good morning, Mr. Etheridge. Your case number is 23 CR 006891H. You're charged with terroristic threats and harassing communications. Do you understand your rights?
Yes, ma'am.
All right, and the announcement I have is negotiated plea, is that correct?
No, Your Honor, this is actually a not-guilty plea. And
Oh.
upon request,
Okay, do you want him to be arraigned or are you gonna do a formal waiver of arraignment later today?
I can file a waiver of arraignment later today.
All right, so we're gonna hear him we're doing a bond hearing?
Yes, Your Honor.
All right. All right, Ms. Falk, please proceed.
You're on mute.
Thank you. Okay, I just wanted to double check because it still said I was muted. This incident happened back on September 16th of 2022 at the victim in this case, whose name is Glenda Lasik. stated she had received text messages from the defendant who had threatened to rape her via text. And based on that information, the officers were able to gather the phone number. One of the text messages, he did send numerous text messages. This was just one of the text messages that was sent to Miss Lasik. And based upon that, the warrant was taken out for the defendant. I will point out that the defendant's history is multi-state in nature. He has a case out of Illinois, 2 cases out of Florida, 4 cycles out of Georgia. His most recent arrest was in Florida in 2023, damage to property, out-of-state fugitive, damage to property, criminal mischief. He also has an Illinois 2010 conviction for aggravated battery against a government official, a 2021 conviction in Florida for criminal trespass and criminal mischief, and a 2013 conviction for battery, simple battery, family violence, abuse of a disabled person, for which he received first offender. Based upon that, it looks like the court at the time gave this defendant and actually not seeing a bond on this. Let me just take a look at the jail record. But we are asking that the bond remain as set, and with the conditions that he stay away from our victim. We would like to sound for the victim at this time, Miss Glenda Lasik, and I will state that he is currently being held on no bond. This case was transferred down, it looks like, from the DA's office, which is how we received the case.
Okay, so he has no bond at this time on this particular set of charges?
I am not showing a bond, so a bond will need to be set since they are being treated as misdemeanors. However, the state would ask for at least a $5,000 bond as to these charges.
All right. Is Ms. Lasik present and wishes to make a statement? I don't see anyone with that name either. Ms. Adams?
Yes, thank you, Your Honor. Mr. Etheridge is actually born and raised right here in Georgia. He lived here for over 10 years, but then he moved to Florida. At the time this alleged incident occurred, he was actually in the custody of a jail in Florida. Furthermore, Your Honor, he's gainfully employed. He's actually a business owner. He purchases storages and then he pretty much flips them, and then with the merchandise that he is unable to sell, he actually gives away to the homeless and helps take care of those who are more in need. He does not have the means to pay a $5,000 bond, Your Honor, especially too because he has been incarcerated. He's been in Fulton County custody for 95 days. But prior to that, he was in custody because he was extradited from Florida. He was in jail in Florida for 6 months. Your Honor, so it would be very difficult for him to be able to make a $5,000 bond. And he does have family, but his family is of little means. Give me 1 second, Judge. So with regards to that, Your Honor, we are requesting a signature bond because again, he has been in Fulton County custody with no bond for 95 days. We're requesting a signature bond or a low bond.
And Your Honor, just briefly, the information in the jail and the information I just found in his CP case did not match up. I did pull an order from bond dated August 14th, 2023. Count 1, Judge Holly Hughes gave a no bond. Count 2, the judge gave a $25,000 bond. So there is a bond as to one of the counts, but it is correct. There is a no bond on one and a bond as to the other, and it's a $25,000 surety bond.
And so with that new information, Your Honor, we are asking for a much less bond. We are asking for a signature bond or a much lower bond. $25,000 is astronomical. We would not be able to pay that at all. And him not being able to pay it, his family not being able to pay it is equivalent to having no bond at all. So we are requesting a signature bond or no bond.
All right. Defendant will receive a $4,000 surety bond, $2,000 each count. He's to have no contact with the alleged victim, stay away from that address, and have no alcohol, drugs, or weapons as a condition. Is there anything additional?
Not at this time, Your Honor.
Nothing from the state.
All right, best of luck to you, Mr. Etheridge. That concludes your case at this time.
Thank you so much.
All right, who do we have next?
Position 18, Moses,
That's,
that's McLean's.
That's McLean's.
What about Mr. Pace, position 19?
I'm sorry, I probably messed that up. I am position.
Yeah. That one's Mr. McLean as well.
I'm happy about it now. As well.
So-
Positions, I think I'm in
Is that-
mistake. I think,
Yeah, on the thing it says
yeah, I'm positions
1
1
through
through 10.
22,
I'm positions 1 through 10.
1 through 10, so
Mhm.
switched it.
Mhm.
Ms. Adams, would you like to do position 15, Monique Jones? Or you need a breakout with her?
I would need a breakout with her. She wasn't
What-
brought. Yes,
What
ma'am.
about position 8, Ms. Daniel?
I'm ready for Miss Daniel.
Ms. Daniel, come on up and have a seat.
And ACDC has heard their rights, correct?
I think we might
Believe so.
be aiming on the middle part of it, Your Honor.
All right, I'll say it one more time very quickly. Ms. Daniel, your case is 23 CR 006791C. In this case, you're charged with terroristic threats and acts with the offense date of October the 29th. You have an absolute right to remain silent. Anything you say can and will be used against you. You also have a right to an attorney. This proceeding is being broadcast over the internet. It's also being recorded. You understand your rights? Yes, is that a yes?
Yes, that's a yes.
All right. And the announcement, Ms. Adams?
That's also gonna be a not guilty plea, Your Honor, and we're gonna be requesting a lower bond.
All right, so are you gonna enter the waiver of arraignment? And we'll go straight into the bond hearing. Ms. Falk?
Yes, Your Honor. The bond on this case was set at a $3,000 surety bond. That was on October 30th, and it was by the order of Judge Morrow. In this case, let me just briefly pull this up. In this incident, on October 29th, 2023 at 1859 King Alfred Drive Southwest, officers were dispatched to that area and in response to a dispute call. They spoke to Miss Genevieve Yvonne Small, who stated that one of the tenants in the rooming house where she lives, the defendant threatened her with acts of violence, stating she would stab her and kill her. Another tenant in the rooming house, Miss Anita Yvonne Edgar, witnessed the incident and corroborated what Miss Small said had happened. Based on that, the state has sent a recommendation to the DA's office to have this upgraded to a felony, since it is a threat that suggests death, which is a felony offense, and we are awaiting a response from the DA. We will state that we had an opportunity to speak with the victim. She says she knows the defendant's mother, and her mother stated the defendant needed somewhere to stay, so she allowed the defendant to come and stay with her. She said this defendant had been staying there less than 30 days. She had heard the defendant yelling, asked the defendant to keep her voice down, and the defendant threatened to stab and kill her. She also stated that once the police officer left with the defendant, she found a knife in the defendant's bed. Miss Edgar did state she is in fear of the defendant, does not want contact. She stated the defendant's mother had already come and gotten the belongings, so there is no need for a law enforcement escort. I will point out that the defendant has a previous first offender for aggravated assault and ag stalking in 2006, and has arrest in 2021 for pointing a gun at another in simple assault and simple battery in 2021. She also has a foreign hold, and it looks like her most FTA was in 2023. Based on all of that, the state is asking that the bond remain as set. And we would like to sound for Miss Edgar in case she is here.
All right. Is it Miss Edgar or is it Miss Small? Miss Small is the victim, right? Miss Edgar is the witness.
Sorry. That is correct, Your Honor. My apologies.
No.
It is Miss Genevieve Yvonne Small.
All right, Miss Small, are you present and wish to make a statement? I don't see anyone that name. So Miss Adams, please proceed.
Yes, thank you, Your Honor. First and foremost, Your Honor, Ms. Daniel vehemently denies the allegations that have been made against her, which is why she's maintaining her not guilty. Why she's entering a not guilty plea. She has a high school diploma, 1 year of technical school. She's a mother of 3 children, the youngest being 10 years old, whom she has custody. She was actually about to move out of that home, and so there's a lot more to it, but today is not the day to hash out all of the facts of this case. But with regards to the FTA that she has, that's actually out of DeKalb County, and she got it because she had a court date while being incarcerated in Fulton County. So it's not because she was trying to miss court, it's because she actually could not make it, because she was in Fulton County custody. She actually just started a job just prior to being arrested, and was in the midst of getting on the schedule. And it was with the Popeyes in Alpharetta. She has absolutely no desire to go back to the home and and she has zero desire to have any contact with the complaining witnesses. With regards to that, Your Honor, we are requesting a signature bond because she does not have money because she has not yet started her job yet. We are requesting a signature bond so that she can get out of jail, get to work, and so she can get on her feet.
How does she bring up convictions that I haven't been convicted?
No. All right, defendant is gonna receive $1,000 surety bond. She's to have no contact with the alleged victim and stay away from that location. Additionally, she's to have no drugs, alcohol, or weapons as a condition of that surety bond. Is there anything additional?
Not at this time, Your Honor. Thank you.
All right, best of luck to you, Ms. Daniel. Who do we have next?
Next, we have position on the probation revocation calendar, Miss London.
I need a moment to speak with Miss London, Judge.
Okay. So you need to speak to all three of those other ladies?
I just need to speak with Miss London and Miss Gibson. I believe the other client is Mr. McLean. Your Honor, if you don't mind giving me a moment, I can go check on Mr. McLean.
Okay, that would work. And Ms. Champion, do you mind sending me the probation revocation calendar? Thank you.
Yes, ma'am.
Thank you so much. I don't know why I don't have it. It's here somewhere. All right, so I guess we will be on a very brief pause. Thank you all.
I got Mr. Aldrich. His position number 1 through 3.
We're not quite ready yet. Mr. McLean and Ms. Adams are coming.
They're doing 1 through 3 right now. What did you say? They're doing positions 1 through 3.
I need to talk to her. I need to talk to her. Your Honor, I did just speak with Mr. McLean. Give me 1 second, I'm looking for the position. Position number 16. He said that's gonna be a not guilty. He said this charge is not holding him, so bond is moved, and so it's gonna be a not guilty plea.
Okay. Is he ready? Is he almost ready to return?
He's almost ready because he had 2 people he needed to speak with, Your Honor. He's trying to finish up.
Okay. So we'll take another one of your positions if we can.
Yes, Your Honor. I do see Mr. Aldridge on. I do need to speak with him, but I am ready. I'll just let everybody know who I'm ready for as it stands right now, just to make things flow a little easier. I'm ready for position number 4.
Yeah, they have to go to different
Okay. Okay. Yeah, I do. Yeah, position number 4 is the only one I have left. Otherwise, the other people I need to speak with.
Who's position 4?
Are we able to do 4?
Let me see what one is on.
Position number 4 is Jericho Ashton. Oh, Mr. McLean is back. Mr. McLean is back.
Okay.
So the next vacancy is called.
What happened?
Oh, I don't know. I clicked off this video. There. Are we
So
muted?
you all done?
Yeah.
No, we're not muted.
You're not muted. Are you ready, Mr. McLean?
Your Honor, Mr. Kemp's case, the announcement is not guilty. Bond is moot.
Yes, I received that from your colleague.
And that's it. Just put him on jail jury or put him on whatever he needs to be on, but he'll be making bond on whatever is holding him. Mhm.
And Mr. Kemp hasn't returned, I don't think. Is he on the screen? Yes.
Oh, he's still in the breakout room. Yeah.
Okay. Does he need to be arraigned or are you going to enter a formal waiver?
We
Mr.
can, I'll ask him for permission to just do a formal waiver. I'm sure it'll be fine.
Okay.
Mr. Kemp, can you hear us? No, not yet.
He's not here.
Let's see if you click on
He's
that.
out of it. He's out of it. You want me to bring him back in here?
Yeah, let's bring him back in the courtroom, Your Honor.
Okay.
McLean, are you ready for Pace, Moses, or Pierce?
Yes,
You are?
yes, I'm ready on all three. There we go. Okay, Mr. Kemp, I've announced to the court that you are not guilty and that bond is moot in this situation today. So I'm going to, with your permission, file a waiver of arraignment, which means that you already know what you're accused of. And you don't need to have the judge tell you what you're accused of or to remind you to keep up with your court dates.
Yes, sir.
Okay, I'll file that for you. Thank you.
Thank you so much.
All right. Not guilty, waiver of arraignment. All right. Can we take another position?
I understand that Pace and Pierce and Moses would be ready if Your Honor would like to go forward with those.
That's fine.
And in the meantime, Your Honor, may I please be placed in a breakout space with ACDC?
Yes. Is your laptop?
Yes, ma'am.
All right. Miss Grace, will you put Miss Adams's laptop in with ACDC? And are we doing Moses first or Pierce?
It doesn't matter to us.
All right, doesn't matter to me either. Whoever is there can come forward.
Come on, Mr.
All right, Mr. Moses. All right, Mr. Moses, your case is 23 CR 006892J. You are charged with simple battery family violence. Do you understand your rights?
Yes, ma'am.
All right, I have that this is a negotiated plea. All right. Mr. Thomas, please proceed. You're muted, Mr. Thomas, if you're speaking.
One moment, Your Honor. I'm finding it right now. Oops.
I'm sorry, Your Honor. This is position 18.
Yes, ma'am.
Okay, thank you.
Mr. Moses.
Your Honor, it appeared that the agreed negotiated plea or negotiated offer and plea in this case is for the defendant to serve 12 months on probation, to serve 204 days of that in custody, credit for the 102 days that he served. Looks like that started on August 5th, 2023, for the balance to be probated, to have no further contact with T-ERA, spelled T-E-A-E-R-A, Freeman, traditional spelling, to complete the Family Violence Intervention Program, to also complete 40 hours of community service, and to stay away from 662 Cascade Avenue Southwest. Your Honor, it looks like our office has been able to get in contact with the victim She may or may not, I don't believe she's on the Zoom call today, but if we could sound for her in accordance with Marcy's law, that'd be greatly appreciated. She states that she agrees with the plea. She also states she would like to stay away from the home, which is the 1371 Kimberly Way Southwest apartment 1207 Atlanta, Georgia 30331 location. And if we could just sound for her in accordance with Marcy's law, that'd be greatly appreciated, Your Honor, but nothing further from the state, I think, at this time.
All right. Before I sound for her, Ms. McLean, was that your understanding of the offer, and do you stipulate to the three elements?
We do so stipulate, it is our understanding. If I may go on mute for just about 10 seconds, I want to explain to him the second address, Your Honor.
Okay, and I'll sound for the victim in the meantime. Is Ms. Tiara Freeman present and wishes to make a statement? Okay, hearing and seeing none. All right, Mr. McLean still speaking with his client. Just let me know when you're ready, Mr. McLean.
Thank you, Your Honor. We're ready. I just wanted to clarify for him the second address names, and there's no problem there. He will stay away.
All right. Please raise your right hand, Mr. Moses. Do you swear and affirm the testimony you give today for the limited purposes of taking the plea will be the truth to the best of your knowledge and under the penalty of perjury?
Yes, ma'am.
All right, thank you. You can put your hand down. Are you under the influence of any drugs or alcohol at this time?
No, ma'am.
Are you, did anyone force you to take a plea?
No, ma'am.
Did anyone promise you anything in exchange for taking a plea?
No, ma'am.
And you understand that by taking the plea, you're giving up your right to trial by judge or jury?
Yes, ma'am.
And you're giving up your right to have the state prove these charges against you beyond a reasonable doubt?
Yes, ma'am.
And you understand that by taking a guilty plea, other aspects of your life may be affected, such as employment or immigration or other things that I may not be able to anticipate.
Yes, ma'am.
And you further understand the requirements that you can't go back to that address on Cascade Avenue, and you can't have any contact with Ms. Freeman. You also have a course to take and some community service hours. You understand all of that?
Yes, ma'am.
All right. As to the charge of simple battery, family violence, how do you plead?
Yes.
I accept your guilty plea at this time. Is there anything additional from
Yes,
Mr.
Your Honor. If he
or
could
Ms.
stay away from if he could agree to stay away from the 1371 Kimberly Way Southwest apartment 1207 address
I
as well.
think he agreed that was okay. Will you agree to stay away from that address as well, Mr. Moses?
I said yes, ma'am.
All right. Yeah, I believe we said that. All right. Anything else, Mr. Thomas, Mr. McLean?
Nothing further, Your Honor.
All right. Best of luck to you, Mr. Moses.
All right, thank you.
Position 1 through 3, all three.
I don't think Ms. Adams is back yet. Is Ms. Adams back? Yeah, Ms. Adams is not back yet. I don't think we're ready for that one yet. All right. Is there another position we can go to?
Hayes,
Yeah.
Pierce. Pierce is next, I believe.
You can let him go. Go ahead, go, you can go ahead and go.
Can we go, position number 22 and 23, Mr. Taylor?
Are you ready for that, Mr. McLean?
Yes, Your Honor. Taylor is also ready.
All right. Mr. Taylor, your case is 22 CR 006329F. You're charged with criminal trespass, and then there's an FTA here as well. You have a right to remain silent. Anything you say can and will be used against you. You also have the right to an attorney, and I'm conducting this proceeding over the internet. Do you understand your rights?
Yes, ma'am.
All right. The announcement I have is negotiated plea.
It is.
Is that correct? And
Yes.
a null process of the FTA once he takes that. All right, Mr. Thomas, please proceed.
Yeah, the negotiated plea is that the defendant will be given a time served offer, or was given a time served offer. It looks like he served 175 days in custody as of today. That's starting on May 22nd, 2023. And in exchange for that plea to that case, we agreed to null pros the failure to appear in position 23. It looks like 23 FTA 001007.
All right, Mr. McLean, was that your understanding that it's a time served plea? And do you stipulate to the three elements?
We do so stipulate. It is our understanding of the plea bargain.
All right, sir, please raise your hand. Mr. Taylor, do you swear and affirm the testimony you give today for the purposes of taking the plea will be the truth to the best of your knowledge?
Yes, ma'am.
All right, you can put your hand down. Are you under the influence of any drugs or alcohol at this time?
No, ma'am.
Did anyone force you to take a plea?
No, ma'am.
Did anyone promise you anything in exchange for taking a plea?
No, ma'am.
And you understand by taking a plea, it may affect other aspects of your life, such as employment, immigration, or things that I may not be able to anticipate today.
Yes, ma'am.
And you understand that you're giving up your right to trial by judge or jury.
Yes, ma'am.
And you're giving up your right to have the state prove these charges against you beyond a reasonable doubt.
Yes, ma'am.
And you further understand that essentially the time you served in the Fulton County Jail should close your case.
Yes, ma'am.
All right, as to the charge of criminal trespass, how do you plead?
Guilty.
I accept your guilty plea. Anything additional?
Nothing, Your Honor.
All right.
Nothing to state, Your Honor.
All right, best of luck to you, sir. That's the end of your case.
Position
Thank-
number 21, Smith.
Okay. I'm sorry, position 21 is, I have Torian Smith. Is that who we're
Yes,
going?
this is Smith, Torian Smith.
Okay. All right, Mr. Smith, your case is 23 CR 006935J. You're charged with battery and criminal trespass. Do you understand your rights today?
Yes, I do, Your Honor.
All right, thank you. The announcement I have always says negotiation pending. What is the announcement for this case?
Your Honor, we have a counter offer, and the state's offer and our counter offer both involve some extra time. In the interest of efficiency, there would actually be no difference freedom-wise if we were to reset this week.
Okay, so you're asking for a reset for 1 week?
That would give us more time to discuss it, Your Honor, and I'll go visit Mr. Smith again and let him know how the discussions are going.
I'm not sure. Do we have space on next week's SAP calendar, Ms. Champion?
Yes, ma'am, I can put them on there.
All right, Mrs. Smith, your attorney's gonna come talk to you. He's in the Fulton County Jail at the time. I know you have a question. They're gonna reset your case 1 week, okay? Mr. McLean will come speak to you after court. All right?
Yes, Your Honor. I thought we had agreed to 60 days. I already spoke with him just yesterday.
I already explained
Okay.
that to the court, Mr. Smith. Your
All right.
offer and her offer both involve some extra time. It gives us a little breathing room to discuss the facts and negotiate with each other. So there's no harm to you by taking this extra week.
They're gonna try to get you a better deal, Mr. Smith. Let Mr. McLean come talk to you. Don't say anything else on the record, because Mr. Thomas is listening and could use what you say against you, okay? And I don't want that to happen. So let Mr. McLean come speak to you, okay?
Thank you so much, Your Honor, and thank you, counsel, for representing me. I really appreciate you doing this hard work.
Thank you.
All right, take care, Mr. Smith. We'll see you next week. All right, who do we have next?
Position number 20, Pierce.
All right, Mr. Pierce, your case is 23 CR 006890F. You're charged with criminal trespass. Do you understand your rights?
Yes, ma'am.
All right, I have that this is a negotiated plea, so Mr. Thomas, please proceed.
Yeah, the negotiation from the state is that Mr. Pierce is to serve 12 months on probation, to serve 34 days in custody. Credit for the 17 days that he served looks like that's from October 29th, 2023, with the balance suspended. No further contact with Rory, pronounced or spelled RORY, Coer, spelled COER. And a stay away from the location of 1207 Bell Avenue, East Point, Georgia, 30344. Nothing further for, if at this time we could sound for the victim, Your Honor, Mr. Rohrer, that'd be greatly appreciated.
All right, is Mr. Coer present? All right, I don't see that name. Mr. McLean, was that your understanding, and do you so stipulate to the three elements?
We do, Your Honor, and it is our understanding.
All right, thank you. Mr. Pierce, please raise your hand. I'm gonna ask you some questions to make sure this is a voluntary plea. Do you swear and affirm the testimony you give today will be the truth to the best of your knowledge under the penalty of perjury?
Yes, ma'am.
All right, thank you. You can put your hand down. Are you under the influence of any drugs or alcohol at this time?
No, ma'am.
Did anyone force you to take a plea?
No, ma'am.
Did anyone promise you anything in exchange for taking a plea?
No, ma'am.
And you understand you're giving up your right to trial by judge or jury by taking a plea today?
Yes, ma'am.
And you further understand that the requirements that you can't have any contact with Mr. Coer, and you need to stay away from that location. But otherwise, the time you served in the Fulton County Jail should close your case.
Yes, ma'am.
All right, as to the charge of criminal trespass, how do you plead?
Guilty.
I accept your guilty plea. Is there anything additional, Mr. Thomas? Or Mr. McLean?
Nothing further from the state, Your Honor.
Nothing further.
All right. All right, best of luck to you. That concludes your case, sir.
Thank you, ma'am.
Position 1 through 3, Aldry.
I don't, Miss Adams isn't back. All right, is there another position we can do at courtroom 2?
Let's see, that was, Pace.
McLean, are you able to do the biomedical, or that's Ms. Adams?
Who's he? What's his name? I think it's gonna be.
Position 19, Mr. Pace.
Mr. Pace is number 19, Your Honor.
I've got it. All right, I have it. It's a negotiated plea. Mr. Pace, your case is 23 CR 006887Y. You're charged with criminal trespass. You understand your rights?
Yes, ma'am.
All right, Mr. Thomas, please proceed.
Your Honor, the understanding, the offer from the state is that the defendant agrees to serve 12 months on probation to serve 120 days in custody, credit for the 61 days that he's already served. Looks like he was booked in on September 15th, 2023, with the balance to be probated, to have no further contact with Chauncey, traditional spelling CHANCEY, Griffin, GRIFFIN, and Brandon Gales, GALES, to stay away from MYND Property Management. Looks like location is 641 Hughes Street Southwest, and another location 700 Tift Avenue, TIFT Avenue Southwest, and 700 Metropolitan Parkway Southwest, all in Atlanta, Georgia, 30310, and for restitution to remain open for 30 days.
Is that your understanding? That's your understanding, you stipulate?
Right, we do so stipulate. We understand that avoid 2 named people and 3 specific places, and that is our understanding.
All right, I'm sounding at this time for Mr. Gales or Mr. Griffin. All right, I don't see any of those names, and if you raise your right hand, sir, so I can swear you in. You swear or affirm the testimony you give today will be the truth to the best of your knowledge under the penalty of perjury?
Yes, ma'am.
All right, you can put your hand down. Are you under the influence of any drugs or alcohol at this time?
No, ma'am.
Did anyone promise you anything in exchange for taking a plea?
No, ma'am.
Did anyone force you to take a plea?
No, ma'am.
And you understand that by taking a plea, you're giving up your right to trial by judge or jury?
Ma'am.
And you're giving up your right to have the state prove these charges against you beyond a reasonable doubt?
Yes, ma'am.
And you further understand that taking a guilty plea to this charge may affect other aspects of your life, such as employment or immigration or other things I may not be able to anticipate?
Yes, ma'am.
And you understand the conditions, you can't go back to any of those 3 locations, and you can't have any contact with Mr. Griffin or Mr. Gales. You understand that?
Yes, ma'am.
All right, as to the charge of criminal trespass, Mr. Pace, how do you plead?
Guilty.
I accept your guilty plea at this time. Anything additional from Mr. Thomas or Mr. McLean?
Nothing
No,
for
Your Honor.
Your Honor.
If
All right.
is needed or proposed, just let us know and we'll see if there could be an agreement prior to or instead of a hearing, but we'll just stay tuned.
Okay, I see Mr. Kelball is on the line. Can we go back to his case?
Yeah.
Mr. Kelball, do you need a chance to interview your client?
Well, I don't have them at this moment. I took them back to housing because I didn't know what time he was gonna show up. So I just swapped these two guys out for,
Oh, okay.
Oh, and Your Honor, could I have Mr. Kelbach call 404-612-2392?
Mr. Kelball, if you make that call, I think Mr. McLean would appreciate it.
So 404-612-2930,
2392.
2392. Sorry. Okay, I will call that number. I do need an opportunity to talk to the client, but let me call that number first, which I assume is Mr.
Okay.
McLean.
It is.
All right, thank you.
Thank you.
Ms. Adams is not back, so there's not much else we can do. Okay, we'll be on a very brief hold.
Yeah. Whatever you just said. Just reiterate. Whatever the judge says, what you got? Wait about a week and then like clerk of the Fulton Court, Fulton County Criminal Court, no, Fulton County State Court. Hey. I just want to let you know that I saw him, but they did not, calendar I had.
Can we mute courtroom 2? Thank you.
Talked to him at length and,
Mr. Kelball, are you ready? Okay, I guess we're not quite ready yet. We'll continue to hold.
Your Honor. I think you may be muted.
Oh, yes, I am. We're holding, Mr. Kelball, unless you had a specific announcement.
I'm sorry. I think I was muted when I was telling you my announcement. Is it possible to reschedule him for Thursday?
Also, you could, who was your client? I'm sorry,
Sherman.
remind me.
Hambrick.
Sherman Hambrick.
Hambrick.
It's
Okay.
Position 11 and position 1 on the add-on.
I'm assuming he was not getting a time served plea today. I'm assuming
that was not the offer.
Okay, I'm assuming that's not what was happening. Ms. Champion, can we reset him until Thursday? Is there room on Thursday's calendar?
There's actually no room on Thursday's calendar.
What about next Tuesday, Mr. Kelball? I know that that's right before Thanksgiving, but that looks like that'll be our only option.
Yes, I'm available on Tuesday.
And is there still room, Ms. Champion, on
Yes.
Tuesday's calendar?
Yes,
Okay.
ma'am.
So we will reset Mr. Hambrick to Tuesday's SAP calendar. Mr. Kelball, it's our hopes that you can interview him before then. That's gonna be a long and difficult calendar. So please try if you can, okay?
I definitely talk to you.
Okay.
I have a question. Do I need to bring him so he can hear this from Mr. Kelball that he's been reset for next Tuesday?
Mr. Kelball, will
I
you
will-
just go see him or give the Goodell a call if you,
I will.
you know?
I will go see him today.
Okay.
All right.
Okay, so that just so that we don't delay Mr. Kelball anymore. Does that conclude your business, Mr. Kelball?
It does, Your Honor.
Well, what about Mr. Jeffries? You're not representing Mr. Jeffries, Mr. Kelball?
Not that I'm aware of. What's Mr. Jeffries' first name?
Ronaldo, I have Mr. Jeffries.
Okay. All right, thank you.
Thank you, Your Honor. May I be excused?
Yes, you may. Take care, Mr. Kelball. Have a good one.
Take care.
All right, Mr. McLean, any announcements? Is Miss Adams almost complete? Do we know? You're muted there at the courtroom too, Mr. McLean.
There we go. They're in the other room, so I'm not sure of how many more minutes.
Okay.
Ready on Jeffries.
Is Mr. Jeffries at medical? Can we do Mr. Jeffries or no?
No, I gotta go get him. I'm going to get him now.
Okay, Miss Adams is gonna come back at some point.
The only other interview left for me to do is Mr. Stephen Kahn, 17. We'll do that by breakout when it's appropriate.
Okay.
Also, Monique Jones at ACDC is 2, please.
I think Miss Adams has ACDC, I believe, in a breakout, so
Right.
we can't do any of those yet.
It depends on what floor they're on. They might have 2 monitors there. I don't know. Maybe it's just one. Might be just one.
I'm sorry, sir. Did you want to do a breakout with Stephen Kahn now?
Yes. Well, no, I don't have the laptop just yet. We'll have to wait a few minutes.
Okay.
Well, technically, there's no one else with you there at courtroom 2, right, Mr.
Oh, that's
McKee?
right. We could do a breakout right here in
We
this
could do
room.
the breakout now since we're just sitting here.
Nobody walks in on me. That'd be great.
All right, so Mr. McLean and jail court iPhone will go into a breakout.
Okay.
And hopefully ACDC will return. Oh, good. ACDC has returned. Is Miss Adams present? Thank you. Great. Miss Adams, what position are we ready to proceed? Oh, are we ready for position one to come back now that Miss Adams is here?
I got Mr. Jeffers instead.
Oh, Mr. McLean is gone now, so can we?
Okay, position 1 through 3. Come on.
Okay, thank you. Mr. Aldridge, your cases are 18 CR 004348J. In that case, you're charged with
And
cruelty to
that's
children.
one count, and the other count is.
Uh-oh, can we mute?
Possessing J. Eagle's property.
Miss
without-
Adams, Mr. McLean's coming through your audio.
Okay.
Okay. I don't know how we're gonna do this. You're gonna have to be able to talk at some point.
I'm gonna go back to the room that I was just in. Give me 1 second, Judge.
Okay, so we'll hold for you to come back. Well, I can still ask if you understand your rights. Mr. Aldridge, in 18, that case I just listed, you're charged with cruelty to children in the third, battery, family violence, distributing obscene materials, and simple battery. In your second case, 23 CR 006774J, you're charged with simple assault, family violence, and battery, family violence. And then you have an FTA, which the state will not process if you plea. Do you understand your rights today?
Yes, ma'am.
All right, Ms. Adams, the announcement is negotiated plea.
I had not had an opportunity to speak with Mr. Aldridge, Your Honor, but if the court would like, we can go to Ms. Gibson at ACDC.
Okay, so, all right, so Ms. Adams will have to speak to Ms. Aldridge. We weren't quite ready.
Yes, sir.
All right, what position do we have at ACDC? Is it position 10?
Yes, Your Honor.
All right, thank you. I'm sorry, Mr. Aldridge, we'll be back with you. Ms. Gibson, your case is 23 CR 006740Y. Your charge was battery, criminal trespass, and obstruction. Do you understand your rights?
Yes, ma'am. Yes,
All right. And the announcement, Ms. Adams?
Gonna be a negotiated plea.
All right, thank you. Ms. Falk, please proceed.
Yes, Your Honor. The state's recommendation in this case is 12 months probation, served 90 days in jail, credit for time served 20 days. That's from October 26th of 2023. Balance probated, 8-week anger management, 40 hours of community service. No further contact with Susan Reinhart. Stay away from Spirit Halloween, located at 608 Holcomb Bridge Road in Roswell. And count 2 is going to be 12 months concurrent with count 1. Count 3 is 12 months concurrent with count 2 with an additional $300 fine. So that total is 12 months served 90 days, balance probated, 8-week anger management, 40 hours community service, a $300 fine, no contact with Susan Reinhart, and stay away from Spirit Halloween at 608 Holcomb Bridge Road. Does the defense stipulate 2 venue, factual basis, and identification for the purposes of the plea?
Yes, defense so stipulates.
And Your Honor, the state would like to sound for Susan Reinhart. I do not see her on here, but just out of an abundance of caution.
And Ms. Falk, how many additional days would Ms. Gibson have to serve?
So she has already served 20 with 2 for 1. That would be 40 days. So she would have 50 days remaining with 2 for 1. That would be 25.
Okay. All right. I'm sounding for Ms. Reinhart. If you're present, would like to make a statement. All right, I don't see her. I know that you stipulated to the 3 elements. Ms. Adams, was that also your understanding of the offer?
Yes, Your Honor.
All right, let's proceed. Ms. Gibson, please raise your right hand. Do you swear and affirm the testimony you give today will be the truth to the best of your knowledge and under the penalty of perjury?
Yes, ma'am.
All right, you can put your hand down. I'm going to ask you some questions to make sure you're taking a voluntary plea, okay? Are you under the influence of any drugs or alcohol at this time?
No, ma'am.
Has anyone forced you to take a plea?
No, ma'am.
Has anyone promised you anything in exchange for taking a plea?
No, ma'am.
Do you understand that by taking a plea, you're giving up your right to trial by judge or jury?
Yes, ma'am.
And you're giving up your right to have the state prove these charges against you beyond a reasonable doubt?
Yes, ma'am.
And you understand that taking a guilty plea may affect other aspects of your life that I can't anticipate, such as employment or immigration?
Yes, ma'am.
And you understand the requirements that you cannot have any contact with Ms. Reinhart. You must stay away from that location. You have some additional time to serve at the Fulton County Jail, and you're also going to be responsible for taking courses, completing community service, and paying a fine. Do you understand all of that?
Yes, ma'am.
All right. As to the charges of battery, criminal trespass, and obstruction, how do you plead, Ms. Gibson?
Guilty.
I accept your guilty plea. Is there anything additional, Ms. Falk or Ms. Adams?
No, Your Honor.
Nothing further, Your Honor.
All right. Best of luck to you. I believe that will conclude your hearing today. All right. Who do we have next?
Your Honor, my last one is Miss last name? Miss Jones, which is, I believe, Mr. Attorney McLean's.
Oh, that's Mr. McLean's case.
Yes, but excuse me, there's a probation case, Your Honor, with ACD, Miss London.
Oh, can we do the probation case?
Yes, come on, Miss London.
Let's see. Let me look at. All right, Miss London, your cases are 22 CR 005740H. In that underlying case, you're charged with criminal trespass and terroristic threats. Then there was a probation violation reported in September of 2019. Today, I'm going to hear from probation to see how they wish to resolve your case. Then I'll hear from your attorney. I'm going to place both you and Officer Allison under oath at this time. If you both will raise your right hand. Do you swear and affirm the testimony you give today will be the truth to the best of your knowledge and under the penalty of perjury?
I do, yes, Your Honor.
All right, you can put your hand down. Officer Allison, will you please give me your recommendation?
Yes, Miss London failed to pay probation fees in a total of $120, victim crime funds in a total of $27, did not report as directed, failed to pay restitution in an amount of $2,000, and did not comply with the orders of a previous hearing on August 10th of 2023. Ms. London has 4 months and 28 days remaining on her probation. Probation is recommending to revoke due to not being in compliance from the last hearing with Judge Morrow on August 10th, 2023.
All right. Ms. Adams, Any response? I'm inclined to follow probation's recommendation in light of the fact that she did receive a second chance in August, but I will hear from you.
Yes, Your Honor. Excuse me, pardon me. Yes, Your Honor. Miss London is not working. She actually lives on the street, so she doesn't have a phone. And she didn't have money to make it to probation. What was going on with Miss London is she was receiving disability, but at some point it discontinued, which disallowed her to be able to make the payments. But she had been receiving assistance from her mom. Her mom was helping her pay. But it's unclear as to what happened as it relates to with her mom helping. But she does know her mother was helping. And then also too, excuse me, with Miss London, she was advised that she needed a police escort to go obtain her belongings from the location. However, she had bumped into the landlord, and they told her that she could come gather her belongings. And when she arrived, she was arrested. She just didn't understand she didn't understand that she needed to call the sheriff before going to get her belongings. Also, to Your Honor, Miss London did not have any identification. And since being in jail, she has received the paperwork to begin the process of getting an identification so that she can get a job, get on her feet, and resume paying her probation fees and fines. Your Honor, so with request to that, we are asking that she be reinstated.
How much time does she have left? She owes quite a significant amount.
Yes, and she
Yes,
has
4 months and 28 days remaining.
Do you believe that if we reinstate it, Ms. Adams, she's gonna be able to do that?
I do believe that once she gets an ID, because she can't get a job without an ID, she can't do anything without it. So once she gets an ID, I do believe she'll be able to start doing something.
All right. I'll reinstate the probation at this time this is a second chance for you, Miss London, okay? So you'll need to stay in communication with your attorneys. Make sure that you report to probation. What if she needs to report within 48 hours, Miss Allison?
Yes, please.
All right, so within 48 hours of your release, you'll need to report to probation. Okay? But
Yes,
I will
thank you.
report this as a probation violation.
Thank you, Your Honor. Appreciate it.
All right, is there anything additional, Miss Adams or Officer Allison?
For the restitution, can we put a timestamp on when she needs to start paying?
Well, she has 4 months to pay. She needs to make her first payment within 30 days.
Do you understand that, Miss London? Okay, thank you. Thank you, Judge.
All right, that is the second chance. All right, that concludes your case at this time, Miss London. Officer Allison, does that conclude your business for the court?
Yes, it does. Can I be excused?
Yes, you may. Take care. Have a good afternoon.
You too.
Bye-bye. Bye-bye. And Mr. McLean is not yet back.
Your Honor, I'm gonna go ahead and go into courtroom 2 so that I can,
Okay.
but in,
Do you want to go on a breakout first and interview
Yes.
Mr. Aldridge?
Yes, I was just about to ask for the same thing.
Okay, so if we can put Miss Adams in with medical.
Okay.
Thank you.
Okay, Your Honor, we do have an announcement in Stephen Kahn, number 17.
All right, the announcement, Mr. McLean.
It appears, Your Honor, that he has made his bond that we had on his booking sheet printout from a few days ago. So bond is now moved. He pleads not guilty. I can waive his arraignment and file that later today. In the
Okay.
meantime, Your Honor, if his bond situation changes, we'll inform the court and reschedule it. But as it stands right now,
He's made bond. Okay.
And if I could just make an announcement on that case, Your Honor, the state has recognized an additional charge and has reaccused to add count 3 battery family violence.
Okay. So he'll need a bond on that charge.
Yes, it will need to be set on that charge.
All right. Where is Mr. Khan? Is he still in the breakout?
they should have left the breakout by now. Let's see.
He's not here. Okay. And Miss Adams is not here to. Okay. I don't know. Miss Grace, are you able to pull him out of the breakout?
Okay.
Your Honor, we have one more left which is Mr. McLean's client.
Yes, Miss Jones. That's fine. We'll do that one next. I just want to see if Mr. Khan can be brought out so we can tell him that he
Did somebody call courtroom 3?
All right, is that Mr. Khan?
Yeah.
Is that Mr. Khan at jail court's iPhone? Okay. Mr. Khan. All right, so we'll need to hold a bond hearing as to the new charge. Mr. Thomas, if you proceed.
Your Honor,
You're muted.
brief facts of the case is that the victim advised that her child's father, the defendant, had been sitting outside of her unit all day waiting for their 8-month-old daughter. The victim stated that when her brother left, the defendant approached her unit and began to bang on her door. Victim stated that the defendant kicked her door down and sorry.
You want to tell me that?
I'm sorry. The victim stated that the defendant has kicked her door down in the past. So she opened the door for him so he wouldn't do it again. And when she opened the door, the two got into a verbal altercation. During the verbal altercation, the defendant walked in her unit without permission, went upstairs and retrieved the child and walked outside. The victim stated that she was on the phone with 911 at the time, and that when the defendant realized she was on the phone with 911, he brought the child back inside and charged at her attempting to take the phone. The victim advised that she threw the phone so that he wouldn't take it, and then he pushed her to the ground. The victim stated that the defendant ran outside after she began screaming, then came back into the unit shortly thereafter. The victim stated that she threw the phone for a second time behind the refrigerator, at which point the defendant pinned her up against the wall. The victim stated that once the defendant realized he wasn't going to get the phone, he finally left the unit again. The victim stated that she was 6 months pregnant with their child and suffered a bruise on the left side of her stomach due to the physical altercation. Your Honor, the defendant has quite an extensive history as it relates to violence. He is a multi-state offender, looks like out of Florida and obviously Georgia. He has arrest for, he has a 2013 arrest for touch and strike battery, domestic violence, a 2021 arrest for battery, touch and strike out of Florida as well, and a 2022 aggravated battery. Offender knew or should have known that the victim was pregnant, domestic violence. We haven't been able to ascertain if it's the same victim, but we do understand that it's the exact same charges in this case, and that is in Florida, and this case is in Georgia. He also has the 2021 battery and cruelty to child in the first out of Clayton. Your Honor, our recommendation would be a $5,000 signature bond. I'm sorry, not a signature bond, $5,000 surety bond with all the standard conditions, obviously no contact with the victim and a stay away from that incident location. That incident location would have been 4755 Yates Road, apartment 5C, South Fulton. And the victim, who I believe we can sound for at this time in accordance with Marcy's law, would be Jade Ingram, Jade Ingram, Ingram.
What was the original bond on the other charges? Do we
The
know?
original, yes, I do know. The original bond, it would have been a total of 2,500, looks like 500 on the criminal trespass and 2,000 on the battery against a female who was pregnant.
Okay, Mr. McLean?
Yes, Your Honor, the state has basically read out exactly the EW, the electronic warrant, that is the basis for the existing count 2 that he already made bond on. So we would ask the court to give him a signature bond on that. He has already in good faith made bond on this case.
All right, as to the additional charge, defendant will receive a $1,500 surety bond with the standard conditions. I am going to sound for Ms. Ingram. Ms. Ingram, if you're present, would like to make a statement. All right, hearing none, he will receive 1,500 surety. He's to have no contact with Ms. Ingram, stay away from that location, have no alcohol, drugs, or weapons. All right, best of luck to you, Mr. DuPont. That concludes your case at this time.
Let me write that. NC and no ADW. Gotcha. Thank you.
Thank you. All right, can we do Ms. Jones? I believe she is position 11. No, I'm sorry. I don't know where I got that. She is position 15. Ms. Jones, have you already spoken to Ms. Jones, Mr. McLean?
We did speak yesterday, Your Honor. There's an additional case, and she wishes to plead guilty to both of those.
Okay, so it's a negotiated plea?
Right. The state has the case number on the additional case.
Okay. I think I do as well. Ms. Jones, your case is 23 CR 006827Y. You're charged with criminal trespass. And I believe your other case is 23 CR 006578J. I don't have the charges there, but the state will inform us. Do you understand your rights? Ms. Jones?
Yes.
All right, do you understand your rights?
Yes.
All right, Mr. Thomas, will you put the offer onto the record for me?
Yes, Your Honor. One moment. Let me pull everything up. All right. Your Honor, the offer from, in this case being 23 CR 006827Y, looks like an offense date of October 31st, 2023, is that the defendant will serve 12 months on probation to serve 30 days in custody, credit for the 15 days that she's already served at this point. Looks like the booking date was that October 31st, 2023 date. For the balance to be probated, the completion of the MHET, no further contact with Merida, MERIDA, Gadson, GADSON, for restitution to remain open for 30 days. I do believe that one moment.
We'll get through this.
I do believe that we have been able to get in contact with the victim in the case, and she has provided us with a receipt. So we'd like to put on the record that the restitution is $599.08. We can provide that to the defense to stipulate and agree to that if necessary. But to continue with the plea, Your Honor, the defendant also has another case. Looks like the other case is 23 CR 006776Y. The offer in that case is for the defendant to serve 12 months probation, to serve 8 days in custody, credit for the 4 days that she's already served. Looks like she was booked in on October 28, 2023, to October 31st, 2023, with the balance to be suspended. Stay away from the Hilton Hotel located at 225 Cortlandt Street, and for this to run consecutive to the current case. And this obviously is a global offer, Your Honor.
Okay. Mr. McLean, was that your understanding, and do you stipulate to the three elements?
Your Honor, we can stipulate the three elements, but understanding, we don't know about the restitution yet, so they're certainly free to send it to us. We'll take a look at the
I'm
restitution.
gonna let it stay open for 30 days. I think that'd be more appropriate, so you have time to review.
And I understand, let's see, I may have missed the consecutive nature of the second case. However, it says balance suspended anyway in what I was offered.
All right, so you do agree and stipulate?
Yes, Your Honor, but that offer is not exactly, the second thing was balance suspended rather than probated.
Your Honor,
Okay.
That's what I announced, balance suspended on the second offer.
Okay,
and it is concurrent, not consecutive.
very good.
Okay,
No
I
problem.
think we're all on the same page now. Wonderful. All right, Ms. Jones, please raise your right hand. Do you swear and affirm the testimony you give today will be the truth to the best of your knowledge? Ms. Jones?
Yes,
All right, do you swear to tell the truth?
yes,
All right, you can put your hand down. Are you under the influence of any drugs, Ms. Jones?
no,
Did anyone force you to take a plea today?
no,
Did anyone promise you anything in exchange for taking a plea? Do you want to take a plea today?
yes,
Are you sure?
yes,
Do you fully understand this proceeding?
no,
You don't understand what's happening today?
no,
Would you like to speak to your attorney?
okay,
I'm not sure that we can take this plea today.
Right,
Mr. McClellan.
we still are in a situation where we could do a breakout right now here in this courtroom.
Okay. All right, we'll do that because I'm not sure we're gonna take this plea. At this point, we might need to reset. I have some concerns. Why don't you speak to her, Mr. McLean? Can we put courtroom 2 in with ACDC briefly? Briefly, Mr. McLean. Because as of Ms. Jones' answers today, I'm inclined to reset this case, even though I understand she would get out today if she didn't have other holds.
Okay, Jay.
Thank you, Ms. Grace.
I'm sorry, Your Honor. Oh, so we're resetting?
No, we're letting Mr. McLean speak to her.
Okay, and
But
I'm
she
not
said she
sure.
doesn't understand what's happening.
Okay, and I'm not sure if we sounded for the victim, that's all.
Let's go into that breakout. All right, we'll be on a brief hold. All right, Ms. Adams, your announcement.
Sorry about that, Your Honor. Yes, with regards to Mr. Aldridge, it's going to be a not guilty on both cases. I'll file a waiver, well, though, a waiver of arraignment, I believe, if I'm not mistaken, may have already been filed in the first case in position number 1, but if not, I will file one in both cases. But it appears he's out on bond on that first case, but with regards to position number 2, we are going to request a bond hearing.
Okay, so he's already made bond on position 1. So Ms. Falk, if you proceed as a position 2.
Yes, Your Honor. If you will just give me a moment, I want to see what his posture is on the cases he's currently in custody on.
Okay.
Just to get an idea of what we're dealing with. Okay, so it appears he has a FTA. Actually, he's not out on bond on his 2018 case. He's got an FTA on that case where he's being held on a $7,000 surety bond, a probation violation on a 14 SC 125283 case where he has no bond. And then on the most recent case, the simple assault family violence battery, he's got a $2,000 surety bond. So I just wanted to make sure we were all on the same page as far as the posture. All right. So on that 2018 case where he's being currently held on the $7,000 surety bond, this incident happened with Paris Hall back in March of 2018. The defendant became upset after Ms. Hall refused to return to the store for him after she had just returned from the store. He blocked the doorway of his bedroom with his wheelchair, and he pushed and knocked into her and began punching her in the head.
I'm sorry to interrupt, Ms. Falk. He's just pleading not guilty on that one. I was doing the bond request on position number 2.
Right. So you do not want to make a bond request on the case.
You don't want a reduction of his
currently on an
bond?
FTA
So
on.
why?
I'm gonna ask him, do you want me to go ahead and try to get a reduction on a bond on both cases, Mr. Aldridge? Medically on mute.
It doesn't seem like he wants that one, so we'll let it stand. So
If it's possible.
okay, so yes, I'm sorry, Ms. Falk. I deeply apologize for interrupting the court. I just wasn't sure.
Not a problem at all. I just assumed if he wanted to bond on the 3,000, he probably wanted to bond on the 7,000.
He does. He does. You can go ahead and continue. I apologize.
All right. So the defendant then began pushing and knocking the victim down and began punching her multiple times on the head and face, causing scrapes and bruises. The victim's two-year-old daughter, London Jones, was present in the room at the time of this incident. And shortly after the physical altercation, the defendant posted a video of him and Ms. Hall engaging in sexual activity on Instagram. Ms. Hall stated she did not know and she never gave her any consent for herself to be videotaped at any time during their relationship or for it to be posted online. Once the victim told the defendant's father about the video, it was taken down. We did have an opportunity to speak with Ms. Hall, and she stated the state's plea recommendation on this was 12 months probation with 120 days to serve, credit for time served 49 days, as well as 40 hours community service, FVIP, stay away from Ms. Hall and her minor child, and stay away from 245 Doan Street. The state is revoking that recommendation. We did talk to the victim, Ms. Paris Hall, and she had agreed with the plea offer. She stated she has not spoken to the defendant in a couple of years. The second case, Your Honor, is a simple assault family violence battery. The state did recommend that case to the DA's office. This happened on October 14th at 27 Peyton Place. Officers responded to that address and made contact with Lewis Hall, who had a black Ruger LCP in his hand. It's a firearm. He handed the officer the firearm and stated he was fighting with his cousin, the defendant. He stated that he arrived home after work and saw his belongings sitting outside. He confronted the defendant, his cousin, who he was living with, and then he tried to use his key to unlock the door. At that point, the defendant, Mr. Hall, broke the sliding door, made his way into the apartment, confronted the defendant in the kitchen, asked him why his things were outside, and he stated, "You don't stay here, you need to get out of my house." Mr. Hall then responded, "Why did I just pay you rent if I don't stay here?" At that point, the defendant told Mr. Hall he would call the police, began reaching for a gun, and Mr. Hall was able to disarm the defendant of the gun. I will point out the reason this case was being recommended is because the defendant currently is a convicted felon, so he is unable and not allowed to possess a firearm. The defendant also had I believe that stemmed from an aggravated assault case. We did have an opportunity to speak with Mr. Hall. He stated he was the defendant's caretaker, that they are not actually cousins. They called each other that. He said this is not the first time the defendant has tried to pull a gun on him, but this is the first time he contacted police. He said he had since left the residence and no longer lives there and has not had contact with this defendant. In that case, we were recommending, as I said, we are recommending a upgrade to the DA's office. The defendant also has, and this is of note, a 2018 family violence battery conviction that also involved Paris Hall, the first victim, where he was sentenced and given 12 months probation with 10 days to serve. So based on all of that, Your Honor, the state would ask that the bond remain as set, in particular because on that 2018 case, he did FTA on that case and has been absent from being able to enforce that case for several years. That's all for the state. We would like to sound from Ms. Paris Hall and Mr. Lewis.
The breakdown of the current case, I know it's 7,000. How is it broken down currently?
So on the 2018 case, that's the $7,000 surety bond on the FTA. On the 2023 case, it was a $500 surety bond on the simple assault and a $1,500 surety bond on the family violence battery. And again, we would just emphasize that bond should remain the same, especially based on the fact he has prior aggravated assault conviction and a prior family violence battery conviction.
Okay, so it's 7,000 on this one. Okay, I'm sorry, her name is Miss Hall. Miss Hall, if you wish to make a statement, I need you to turn on your camera and raise your right hand. You are not required to make a statement, however. Okay. And Mr. Hall, I don't see anyone with that name, but if you are present and wish to make a statement, this is your opportunity to do so. Okay, Miss Adams. Oh, okay, Miss Hall, if you wish to speak, raise your right hand. Do you swear and affirm the testimony you give today will be the truth to the best of your knowledge under the penalty of perjury?
Yes.
All right. I am not sentencing the defendant today. He has pleaded not guilty. That means that there will be other proceedings whereby your testimony regarding what happened will be critically important. Today, that's not of the utmost importance. What's most important is whether you wish to have any contact with the defendant and any concerns you may have for your safety. That's what I'm most concerned with hearing about today. Okay, so what would you like to tell me, Ms. Hall?
No, I don't have any concerns about my safety. I wish him the best of luck.
Okay. Anything else you'd like to tell me, Ms. Hall?
No, that'll be it.
All right, thank you. I appreciate you coming to court and making that statement. All right, Ms. Adams, please proceed.
Yes, thank you, Your Honor. Mr. Aldridge, his father of two daughters, ages 9 and 10 years old. He's born right here in Georgia, born and raised right here in Georgia. He works in the film industry. He did once have a job. His last job was with BET as a location assistant. And when he was arrested, he was in the process of getting his GED so that he can go to school for computer science. Your Honor, we do understand that he has missed court, but Mr. Aldridge has been in and out of the hospital, having multiple surgeries over the course of the last 3 years. So when he missed court, it was because he was in the hospital. Additionally, Your Honor, the facts of the case obviously are to be argued later, right? But he does vehemently deny them. In addition to all of that, he does stand firm in his position with regards to the 2023 case that the complaining witness did not reside with him. He was his caretaker. He had access to his home, but he did not live there. And additionally, he did want me to make sure I put it on the record that when the police arrived, his wheelchair had been taken and disassembled by the complaining witness. So, Your Honor, the home that the state has recommended to be that he stay away from is actually his home. and the complaining witness does not live there. So we are requesting that his bond be lowered and that he be allowed to return home if his bond is paid and once any other, matters he has with the court have been handled.
And Your Honor, the state has no objection to the removing the stay away, since we did have a conversation with Mr. Hall and he stated he does not live there any longer.
Okay. All right, so we'll start with that case first. For the case ending at the case at position 2, defendant's going to receive a $1,500 surety bond. It'll be $500 count 1 and $1,000 count 2. He's to have no contact with Mr. Lewis and have no alcohol, drugs, or weapons as a condition of that case. I will not require the stay away. For the 2018 case where there's currently a $7,000 surety, it's going to be as follows. Count 1 will be $1,000 surety. Count 2 will be a $3,000 surety. Count 3 will be $500 surety, and count 4 will be $500. That should be a total of $5,000 surety, I believe. I'm very bad at math. Yes, and with the same conditions that were already in place: no contact with the alleged victim, stay away from that location, and have no alcohol, drugs, or weapons. Is there anything additional?
Nothing further at this time, Your Honor.
Can you repeat it's a $1,000 surety on count 1, a $3,000 on count 2, $500 on count 3 and 4?
Yeah.
Okay, just want to make sure I got that down. Okay,
Yes.
Thank you, Your Honor.
All right. Best of luck to you, Mr. Aldridge. That concludes your cases at this time.
Thank you, Your Honor.
All right, back to Ms. Jones. Mr. McLean, does she want to take this plea? It does not seem like it.
No, Your Honor. What I need to ask the court for is a 1 to 2 week reset for a social worker visit and a possible mental health referral based on the social worker visit and interview. She is in need of housing, and we can work on 2 things at once.
Okay, so you're requesting a BHET and a reset to 2 weeks state on purpose or 1 week state on purpose?
Well, I'll have the social worker talk with people on my staff to see if the BHET would be necessary. I realized that had we gone through the plea, MHET was going to be part of the probation. But yes, a 1 to 2 week reset for the purpose of finding housing and further discussions with her of her understanding of the case.
All right. Ms. Champion, is there still room on next Thursday? I'm sorry,
Yes,
next
ma'am.
Tuesday.
Next
I'm sorry,
Tuesday. Yes, ma'am.
not to Thanksgiving. All right. We will reset Ms. Jones 1 week. Ms. Jones, your attorney will speak with you between now and then. Your case is reset. All right. Best of luck to you, and ACDC can be excused.
And Your Honor, the state has a couple of announcements. We received several orders from the DA's office that I wanted to put on the record.
All right.
And Your Honor, I just forwarded those to Ms. Champion and Ms. Grace for your signature. The first is going to be position 12, Mongerell Hodges, that has been accepted as a felony.
Okay.
So the state's recommendation is no longer valid. Position 8, Anisha Daniel, has been accepted as a felony. We already addressed that one, but I just wanted the court to know that was accepted as a felony just now.
Okay, understood.
Position 4 was accepted as a felony. And so the state's recommendation is void.
Okay. Understood.
Thank you, Your Honor.
Your Honor, with
All right.
regards to position 4, we hadn't done that one yet, so my client is not aware that his case is being moved up.
Okay, well, if they bring him, we'll tell him at that time.
Yes, sir.
Or if he's not brought, I'm sure your office can let him know the unfortunate news at this time.
Yes,
All
sir.
right, who do we have next?
That's also true, by the way, Your Honor, of number 12, because there had been a notation of requested transfer to DA's office. I didn't know if that meant that in the past.
Well, we'll do the same thing. We'll do the same thing. We'll let them know. All right, who do we have next?
This is position number 12. He's right here.
Okay, So, I think you just heard that, Mr. Hodges, your case has been upgraded to a felony. We will not be addressing your case today, unfortunately. Your attorney will speak to you between now and then to tell you what the next steps will be, okay?
I don't understand what you mean, a felony, what?
Mr.
Okay,
Hodges, that'll be a
I
different
understand.
story.
Don't say too much. Your case has been upgraded. Your attorney will explain to you what that means, okay? All right, best of luck to you, Mr. Hodges. We're not going to be addressing your case today.
Position number 14, Mr. Jeffries.
Okay, Mr. Jeffries, your case is 23 CR 00682-3E. You're charged with simple battery family violence. Do you understand, right?
Yes, ma'am.
All right. The announcement I had was, I'm sorry, was it negotiated plea, Mr. McLean?
Not guilty. He needs a
Oh,
signature.
not guilty. Okay. Are we being heard on bond?
Yes, Your Honor.
All right. And you're going to enter a formal waiver of arraignment?
I can do that, Your Honor. Certainly glad to, yes.
Thank you. All right. Mr. Thomas, if you give me the state's position regarding bond.
Yes, Your Honor, one moment. Okay, I found it. Your Honor, brief facts of the case is that on October 3rd, 2023, the officer was dispatched to 590 Cascade in reference to a dispute with a person down. That location was actually Kroger. The officer spoke with the victim, who advised that she was trying to get her husband, the defendant, some crazy glue. She advised the defendant became irate and told her not to talk to anyone. She then threw the crazy glue at him, at which point he returned that by stating that he would kill her, then slapped her with both hands in the shoulder. The victim advised that she could not see and she is legally blind. The victim also advised that her back and her shoulder hurt and her right shoulder hurt. The officer discovered that this is not the defendant's first incident with the victim. Actually, last month to that day, September 11th, the defendant was arrested in conjunction with that victim. The victim advised that the defendant has always been verbally abusive, but within the past 6 months, since he's been, under the influence, the abuse has escalated to being physical. Your Honor, they have quite an extensive history together. The defendant himself is a convicted felon. Looks like everything from battery family violence in 2010 to aggravated assault and battery family violence out of Clayton in 2016, where he received 5 years to serve, 6 months balance probated. And it looks like they also had a 2023 conviction, simple battery family violence. It is the same victim. He was sentenced, looks like September 26, 2023. He received 12 months probation and he had a no further contact in place. Obviously, this date came subsequent. And so he violated that no further contact and that probation, shall I say. He also had a 2017 battery family violence arrest out of Clayton and a 2015 aggravated assault and battery family violence arrest out of Clayton County. Your Honor, the state's position is the bond as currently set, which I believe is $5,000 surety, is more than reasonable. And so we just ask for that to remain the same with the standard conditions. And since this is a bond hearing, the victim's name is Tarsheia, Lane, traditional spelling. And if this time we could sound for her in accordance with Marcy's law, that'd be greatly appreciated, Your Honor.
Okay. Is Ms. Lane present, wishes to make a statement? All right, Mr. McLean.
Your Honor, Mr. Jeffrey's brother is an over-the-road trucker and he doesn't have his phone number to call to him. His brother will occasionally call him. They check on each other and make sure they're doing okay. Your Honor, given that he has no resources in order to reach anybody who can make a bond or help him make a bond, he is financially unable to do that. He's asking the court to consider a signature bond. He does have some medical problems and currently he's residentially challenged, but he can get his mail by letting us know of a shelter name where he can check it.
Okay. Is there anybody from pretrial on the line? Ms. Tyson, can I have the defendant's history, please? Or see what pretrial has? Ms. Tyson, if you're speaking, you're muted.
Lord, I am talking. I'm sorry. Mr. Jeffries, he has 23 arrest cycles beginning in 1980. He has 5 felony convictions outside of the 10-year period. One's for burglary. Let's see. 2 of them are felony theft cases. A second for burglary with burglary. A third one for burglary and voluntary manslaughter. Within the last 10 years, he has a felony conviction out of Clayton County for receipt, possession, or transport of firearm by a convicted felon. Looks like he has a total of 3 violations of probation, 1 FTA.
That's sufficient, Ms. Tyson. Bond will remain as set, Mr. McLean. Is there anything additional, Mr. Thomas or Mr. McLean?
Nothing further, Your Honor.
Nothing further from the state, Your Honor.
All right, best of luck to you, Mr. Jeffries. That concludes your case at this time. All right, I have that we finished almost the entire calendar. I did have a question about position 7, I believe.
I gotta go get her. She's in the medical ward, so I gotta take these guys back, then I grab her and I'll be around shortly.
Wait, before you grab her, I saw a note that said, do we still need her, Mr. McLean? Are we gonna be addressing her case today?
Your Honor, that's my case.
Ms. Adams, I apologize.
It's okay. I did not get an opportunity to speak with her yesterday. I waited for quite a while and she wasn't brought down due to staffing at the jail.
Okay, so she needs to be brought. That's fine. What about position 13? Is there an announcement for that position?
That is
I have that it's gonna be reset. Has an evaluation already been ordered for position 13?
Your Honor, but it needs to be, we would like to set up the
You're requesting an evaluation?
Well, we're requesting it go directly to the competency calendar and
I know everyone keeps asking me to do that, but what my understanding is, in order for you to go to that calendar, you have to be pending an evaluation.
Your Honor, he's had evaluations in the past. This is not his first case with Fulton County. Between the division and competency. So we are requesting that. Because we have had a social worker go to see him. They're not always consistent with him, but we know that he is unable to get through court.
Okay. Since he's already had evals, and I'm assuming that they support the request, Ms. Champion, can I put him on the competency calendar in 2 weeks?
Yes, ma'am.
All right, so he'll be reset to that calendar in 2 weeks, and we will be waiting on position 7. Is that the only position we have left?
And when you say 2 weeks, Your Honor, are you talking about the 30th?
Oh, you're looking at a calendar and wanting me to be. Well, hold on, but yes, competency is only on Thursday, so
Yeah,
2 weeks will be the 30th.
I just wanted to make sure it wasn't the 23rd. I was counting 2 Thursdays, so I was double checking.
None of us would like to attend on Thanksgiving.
Oh my gosh. Yeah, sorry. My apologies.
Your Honor, what is our court schedule for Thanksgiving week?
I don't know, but I'm not coming. So
Mr. McLean, my apologies. It's no court on the 23rd, but there is SEA on the 24th.
Very good. Thank you.
Again, I'm not coming, so I'm unaware.
Jeffries denied bond change. The bond remains the same. Guilty or not guilty. He made a bond request. She said no, stay the same. What's the lunch? I'm sorry. 1 week, he said. Yeah, Jones was 1 week. have that down to me. Bond didn't know that they had added the third charge, so we argued bond on the third charge. So they asked for $5,000 and she said $1,500.
I'm sorry, you're on a position number 2, the add-on DeAnthony Moses. He was also on the regular calendar, position 18. He took a plea on that case, but
They're
here,
They're gonna, no, the state is gonna null process that one, is
Okay.
my understanding.
I actually emailed the null pros.
okay, let me
I
just.
want to say it was about an hour ago. But I can double check and re-email it if you didn't receive it.
Miss Grace has it. I can get it from her.
Yes, Miss Champion. I made sure both of you were on the emails, but again, I'll just forward it to you so you have it again.
That's okay, Ms. Falk. I have it. She just gave it to me.
Okay, thank you.
In the meantime, Ms. Champion, do we want to review the calendar since we only have one position left?
Yes, ma'am.
Thank you.
Position number 1 is going to be reset further notice, jail jury, with the amended bond of $5,000 good bond. Position number 2 is reset further notice, jail jury, with the amended bond of $1,500 good bond. Position number 3, which is the FTA, will also be reset further notice. Position number 4 is transferred to Superior Court. Position number 5 was a plea. Position number 6 is going to be reset SAP 1121. Position number 7 will Holden. Position number 8 is reset further notice. I'm sorry, that's going to be transferred to Superior Court. Position number 9 is reset further notice, jail jury, with the amended bond of $4,000 good bond. Position number 10 was a plea. Position number 11 is reset SAP 1121. Position number 12 was transferred to Superior Court. Position number 13 is going to be reset to the SAP competency calendar 1130. Position number 14 is reset further notice, jail jury. Position number 15 is reset SAP 1121. Position number 16 is reset further notice, jail jury. Position number 17 will be reset further notice, jail jury, with the added charge of the battery, family violence, with the $1,500 good bond. Position number 18 was a plea. Position number 19 was a plea. Position number 20 was a plea. Position number 21 is reset SAP 1121. Position number 22 was a plea. And position number 23 was a null pros. Add-on position number 1 is reset as SAP 1121. And add-on position number 2 will be a null pros. Any questions?
Thank you, Ms. Champion. Great job. We're just gonna wait on that last position, then we'll be complete.
This is Officer Goldie from the medical unit. She's on her way. She's just on a walker. It's just taking her a little bit.
That's okay.
longer. But yeah,
That's
she's right down the hall. She's on her way.
Thank you.
You're welcome.
And you all have not had the opportunity to speak to her, correct?
That's correct.
Okay, so we'll go ahead and as soon as she arrives, Miss Grace, will you put them in a breakout?
Oh, here she is right now. She's position number 7.
All right, good morning, Miss Combs. I'm gonna put you into a meeting with your attorney so your attorney can speak to you and figure out how we're gonna resolve your case, okay? Miss Grace, if you go ahead and start that breakout, please. Thank you.
That's medical and who, Judge?
Oh, and Miss Adams, are you gonna use your laptop again? I think she's gone. Okay. I'm assuming she's planning to use her laptop.
Okay, Miss Adams and medical, okay.
I believe so, because she's not in
Apologies.
courtroom 2 anymore.
Yes, I'm on
Yes,
my
she's
laptop.
there. She's there. Okay, thank you, Miss Adams.
Your Honor, I'm back with an announcement.
Yes, please proceed, Ms. Adams.
Yes, Your Honor. I just spoke with Ms. Combs. I would like to have a reset to the competency calendar for the 30th to give our social worker an opportunity to evaluate her.
Now, the same question is gonna attach. Has she had an evaluation in the past?
To my knowledge, she has not.
Okay, so what if she hasn't, what we can do is we can order a BH, or that's the same as a social worker visit, and reset her 2 weeks to regular SAP, which,
Okay.
is not that much different, really.
Okay.
And then if presuming we have room, do we have room, Ms. Champion?
Yes, we do.
Okay, so we're gonna reset her 2 weeks to SAP for further discussion and evaluation by a social worker. And then from there, should she require evaluations, we can go with competency.
And then
Okay,
for 2 weeks, do you want it to be on the 28th or on the 30th?
I was gonna put on the 30th since it's the same day as there would be that calendar.
Okay. Okay.
All right.
Yes, thank you, Your Honor.
All right, I believe we've completed the state all purpose calendar. We've already reviewed it, so take care, everyone, and have a good rest of your afternoon.
Have a
Bye-bye.
good day, Your Honor.
Have a good one, Your Honor.
Bye-bye.